Good morning, students. Hope I'm audible. So today, uh, before we proceed towards the actual CSEET course, I would like to draw your attention to something. So if you are following our YouTube channel, you would have seen this community post. I thought let me reiterate this again, once again in fact. So if you look at this is a strip about government sector versus private sector. See, I would suggest you to first of all read this community post put up by CS Lok. The reason being, I think one of our students actually was asking us about the scope of company secretary vis-a-vis the government jobs. So most often, many students have this misconception that government jobs are secure and professional qualifications like CACS aren't, but that isn't the case. I cannot make my case here in a very small amount of time, but I would suggest you to read this post and also the strip which is attached. So, and also I would like you to share it with others, whoever tells you that CS course doesn't have any scope. So do read that, and you don't have to worry about the future. In fact, let me tell you my own case in a minute or so. I am a company secretary. I have qualified as a company secretary, but I have never practiced or nor I have ever worked as a company secretary. I have been a full-time teacher, and it's been 10 years since I qualified, and without even being employed ever as a company secretary or practicing ever, I'm still able to make a career out of it. So whoever tells you that there is no scope for CS doesn't really know anything about CS. So please don't listen to them. That's it. Okay. Anyway, let's get on with the lesson then. So we had completed the Contract Act. Let me move to the other chapter, that is the Constitution. We have to finish Law of Torts. I'll come to that once I'm done with Constitution. So let us look at what exactly we have in store here. One thing which I noticed with respect to the subject material here, or the reference material, the institute has used high flown language. I don't know why, but anyway, let's see. It's a very flowery language which they have used in this chapter. Let me try to make it simpler for you. The Constitution, which lays down the basic structure of nation's policy, is built on the foundations of certain fundamental values. Okay, what are those fundamental values on which the Constitution is built on? We'll read those. Let's see. The Constitution contains what? Preamble, the fundamental rights, and the directive principles. So these three can be considered as the soul of the Constitution. That is what they say. So the Constitution places a preeminent emphasis on the values of liberty, justice, on treating all citizens as equal before law. So that is, the major emphasis is placed on that. That is, to treat everyone equally. So that is what the Constitution is all about. The people of India derive their existence as political community from the Constitution, which we the people gave to ourselves. That means we elected our government, and that government gave us the Constitution. In effect, we gave to ourselves this Constitution. Again, these type of facts are important from the point of view of exam. For instance, the Constitution of India came into force on Jan 26, 1950. So they may ask this question. What does it deal with? It deals with the structure of the government. The Constitution makes detailed provisions for the rights of the citizens. It is contained there. And other persons, not only citizens, and other persons also, they may not be citizens, in a number of entrenched provisions, and for the principles to be followed by the state. So whenever they refer to state here doesn't mean any particular state, but the government machinery as a whole. So that is also mentioned, directive principles of state policy, the principles to be followed by state in sense, again, government. Where is it mentioned? Directive principles of state. So now what about the preamble then? Preamble to the Constitution sets out the aims and aspirations of the people of India. So it declares India to be sovereign, socialist, secular, democratic, republic. See, I don't think everything was there when we actually formed the constitution, but few of them were probably added later on. So that's about it. But these are the things which are there right now in constitution. What does it say? So it declares India to be sovereign, socialist, secular, democratic republic and secures to all its citizens. That means everyone has the right to justice, equality, liberty and fraternity. Okay. What is the sovereignty? Sovereignty is in the strict and narrowest sense of the term implies independence all around, within and without the borders of country. So that is something which is given to us. That's what I was trying to say. The word socialist was not there, but later on it was added by the 42nd Amendment, which aims to secure to its people justice, social, economical and political. So whether or not this is correct, we can debate it later on, but this was added as part of the 42nd Amendment. It was not originally present in the Constitution. Again, there is this whole debate about federal or unitary. I don't think there is scope for this in our subject because it's a lengthy debate. I won't get into that. You read it as a story. I don't think there can be any questions with respect to this. But let's move on to the rights, that is fundamental rights, a very important topic. So what are the fundamental rights which is given to the citizens? Right to equality, right to freedom, exploitation, against exploitation, right of freedom of religion, you can practice whichever religion you feel or follow, cultural and educational rights, constitutional remedies. So these are the fundamental rights given to the people. The Constitution seeks to secure to people the liberty of thought, expression, belief, faith and worship. So you have liberty. Liberty means you have full freedom to think, express, believe, have faith in something and worship. Equality of status, according to Constitution, every citizen is the same. Opportunity and fraternity, assuring the dignity of the individual. So the Constitution tries to uphold all these values. How effectively we are able to do that practically is a different thing, but it is already entrenched in the Constitution. So where are these rights mentioned? They are mentioned in respective articles. If you are able to remember these, that is the article numbers, well and good. If not, also it's okay. Right to equality is mentioned in articles 14 to 18, and then like that we have 19 to 22, right to freedom, right against exploitation 23 and 24, so on. Okay, as I said, if you are not able to remember, it's okay. Don't get confused, because if at all in the exam, if they ask this and if you are not sure, so then it will be difficult. But anyway, you can still opt for some option. No, there is no negative marking. Let's move on. This is very important. Previously, the right to property under Article 31 was also guaranteed. Just like right to various things, fundamental rights, there was one more right which was actually withdrawn. I think that is the only right which has been withdrawn since the formation of the Constitution. So this right to property, which was a fundamental right, has now been made a legal right. That means you only have legal right over your property, not the constitutional right. So when was it withdrawn? It was withdrawn by the 44th Constitutional Amendment in 1978. I wonder why did they even do this? Anyway. This is very important. No fundamental right in India is absolute. Absolute in the sense it is not without its qualifications. That means it doesn't come without the conditions. So whenever we say right to freedom of speech, does it mean that I can say whatever I want and get away with it? I wish it was the case, but unfortunately it isn't. So there are few reasonable restrictions. How reasonable they are, it's up for debate, but there are restrictions. There is no confusion about that, at least. In the interest of state by the valid legislation. That means who can impose such reasonable restriction? Mostly the state is the one which imposes such reasonable restrictions. We'll come to that in a minute, but before that, let's see. From the point of view of the persons to whom rights are available, the fundamental rights may be classified as below. So now they say there are certain rights which are guaranteed only to citizens. Articles 15, 16, 19 and 30. So that would be right to equality. Then 19 and 30 means cultural and educational rights. Articles 14, 20, 21, 22, 23, 25 and 27 and 28 are available to any person on the soil of India. That means whoever is in India, it could be not a citizen or some foreigner, so to them also it is available. The rights guaranteed by Articles 15, 17, 18, 20, 24 are absolute limitations upon the legislative power. Okay. Anyway, so they have defined who the state is. The government and parliament of India. As I said, it's basically the government machinery. So who are those? First of all, the government, then the parliament. One second. The government and the legislature. This would be the central government. This would be the respective state governments. Then all local or other authorities, they say. Okay. That is also there. Local authorities, it could be a municipal corporation, etc. Within the territory of India, under the control of government of India. Wherever they are controlled by the government of India, or if it is within the borders of India, then also we will consider them as state. So again, they have tried to define state further. Not very important. Let's not worry about it. Now let us look at the justifiability of fundamental rights. So let me just take this off. Article 13 gives teeth or powers to the fundamental rights. It lays down rules of interpretation in regard to laws inconsistent with or in derogation of the fundamental rights. What they are trying to tell us is, sometimes what happens, even though Constitution gives you certain rights, there may be other laws which may look contrary to the constitutional rights. In such a case, what to do? So we have this Article 13 which gives us the rules to interpret certain laws which are contrary in nature to the fundamental rights. Let us look at the existing laws. That means the laws which are already in force. The laws which were in force before the commencement of Constitution. So now what the judiciary or how do we justify that fundamental rights? A declaration by the court of their invalidity, however, will be necessary before they can be disregarded, and declares that pre-constitution laws are void to the extent which are inconsistent with the fundamental rights. A declaration by the court of their invalidity. That's all is necessary to do what? To disregard all those laws which were there earlier, because back then most of the laws which were prior to Constitution were enacted by the Britishers, so the colonial occupiers. So they may not have thought of all these things, and whatever laws they enacted might have been contrary to the constitutional rights, because they never intended to give us any rights. They just wanted to make profit out of this occupation. So what does the law say, or rather what does the Constitution say? If it's already in existence, a mere declaration by the court of their invalidity will be sufficient. Okay, will be necessary rather. Next, future laws. That means all those laws which are enacted after the Constitution was created. So let's see. Laws made after the commencement of the Constitution. After the Constitution comes into force, the state shall not make any law which takes away or abridges the rights conferred by Part 3. That means either it reduces the rights or takes away the right completely. Such laws cannot be passed by the state. Okay. So when? After the Constitution has been formed. So that is after 1950. Then there is this amendment. Let's see what exactly is this. By the Constitution 24th Amendment 1971, a new clause was added. Let's see what exactly it is. Nothing in this article shall apply to any amendment of this Constitution made under Article 368. Okay. Okay, Article 13 came up for judicial review in a number of cases, and the courts have evolved doctrines like doctrine of eclipse, severability, prospective overruling, acquiescence for interpreting the provisions of Article 13. Again, if you really want to dig deep, there is enough material for you to study for months together with respect to all these case laws when it comes to Constitution. But from the point of view of exam, it's not very important, but just know that try to ascertain or rather accumulate facts for now, and try to read this as a story. If there is anything which you haven't understood, you can always drop a comment below so that we can get back to you. Let's move on to Article 14, that is the right to equality. Articles 14 to 18 of the Constitution deal with the equality and its various facets. Okay. The general principle finds expression in Article 14. Let's see what exactly is that general principle is all about. Equality before law. The law should treat everyone as the same, so there cannot be any partiality. Prohibition of discrimination on the grounds of religion. So you cannot be discriminated on the grounds of religion or race, caste, sex, or place of birth. So it's there. Equality of opportunity in matters of public employment. So when it comes to considering someone for the employment, so equal opportunity should be given. So there cannot be any prejudice there. Then abolition of untouchability. We had this horrible practice in the country. So Constitution has gone to set it right. So according to the Constitution, at least, there is abolition of untouchability. Then abolition of titles. We had all these titles earlier. So there were kings, queens, etc. before the independence. Now all those titles have been abolished. So we no longer have monarchy. So there are no kings, even though some people may refer to them still as kings. So again, they have given the explanation to that. Article 14 applies to all persons and is not limited to citizens. A corporation which is a juristic person is also entitled to the benefit of article. Okay. The right to equality is also recognized one of the basic features of Constitution. This is very important. Which is that article which is not limited to citizens? That is Article 14. It is applicable to even companies as well. So just try to remember this. Right to equality, not restricted or limited only to citizens. It is available to corporations also. Okay, there is one more article, that is Article 15. This reminds me of the movie Article 15. If you haven't watched it, please do watch. It's a nice movie. Article 15 lays down that no citizen shall be subjected to any disability, restriction or condition with regard to access to shops, public restaurants, hotels and places of public entertainment. So that is there. Okay. The use of wells, tanks, bathing. See, if they had to specifically mention this, that no citizen shall be subjected to any disability, restriction or condition with regard to these things, maybe we had all these problems earlier. So the Constitution was very clear about these things, that you cannot restrict access to shops, you cannot restrict access to public restaurants or hotels or places of public entertainment on the basis of certain things. So that is what they are trying to say. And also, not only that, also use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partially out of state funds or dedicated to the use of general public. Either if you are maintained by the government partially or wholly, or if your premise is dedicated to the general use of or use of general public, even in such cases you cannot restrict whoever you wish to restrict. That power you do not have. No citizen shall be subjected to such problems, because we had these problems, there is no doubt about that. So to set it right, we have these provisions in Article 15. Also they say Article 15.1 and subsection 15, Article 15.2, what is it? Okay, no, not that, sorry. Under Article 15.3, the state can make special provision for women and children. Okay. So it is under this provision that the courts have upheld the validity of legislation or executive orders discriminating in favor of women. So they said in some cases there were legislation or executive orders in favor of women. So that was upheld through which article? Article 15.3, because Article 15.3 gives the powers to state to make special provisions for women and children. Also, Article 15.4 permits the state to make special provisions for the advancement of socially and educationally backward classes of citizens, scheduled castes and scheduled tribes. So that power is vested with the state. Okay. Again, the same things are being repeated. Obvious ones, I won't get into that because there is no point in discussing something which is so straightforward. All this is about the employment, equal opportunity given for employment. I'm just striking off here so that it is clear for me. But what you should do is you should just read it as a story. There's nothing of much importance here. Just try to remember which article is giving you the right for equal opportunity in terms of public employment. Abolition of untouchability. Article 17 says that untouchability is abolished. It says that it is abolished. I hope it is abolished. And its practice in any form is forbidden. See, why did I say I hope it is abolished? Because there are so many things in Constitution which are there in the Constitution, but in practice it may not be the case. So even though we have all these things, practically is it is difficult to implement everything practically. So as far as possible, we have tried to implement everything, but certain things we are yet to improve or overcome few of the age-old horrible practices. Anyway, let's move on. Article 17 says that untouchability is abolished and its practice in any form is forbidden. Okay, so it is a punishable offense according to law. Yeah. Abolition of titles, I have already told you. Okay, to do away with the practice article, that is that what is that practice of titles which were given by Britishers. What did the article 18 say? No title not being a military, that means if it's a military title you can keep it, or academic distinction, like for instance someone may be referred to as doctor because they would have completed their PhD. So in such cases you can keep your title. Okay, shall be conferred by the state. Apart from that, apart from military title, apart from academic distinction, no other title shall be conferred by state. No citizen of India shall accept any title from any foreign state. If some other state, or some other foreign country gives you any title, you will not accept it. No person who is not a citizen of India shall, while he holds any office or trust under the state, accept without the consent of the president accept without the consent of the president any title from any foreign state. That means if you are holding any office of trust under the state, under the government, and you are not a citizen, okay, then also you will first get the consent of the president and only then you will accept the title from foreign country. No person holding any office of profit or trust under state shall, without the consent of the president, accept any present, emolument or office of any kind from a foreign state. That means if you are already holding office of profit under the government here in India, then you cannot accept any of these things. So now 6 freedoms. What are those 6 freedoms? They are interesting. Let me just drink water. Freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form association or unions, freedom to move freely throughout the territory of the country, that is India, reside and settle in any part of the territory and practice any profession, or to carry on any occupation, trade or business. So these are the freedoms which the Constitution guarantees its citizens. Okay. So again, they are given the respective article number. Article 19 is the one which gives the freedoms, various freedoms. This is very important. None of these freedoms is absolute. That means you cannot say all these freedoms are without conditions. No, they all come with conditions, subject to reasonable restrictions. Again, we are looking at reasonable restrictions. The restriction can be imposed by law and not by a purely executive order issued under a statute. That means the executive cannot impose the restriction, it should be imposed by law, some law. The restriction must be reasonable, but who will decide what is reasonable? That is up for debate. The restriction must be imposed for achieving one or more of the objects specified in the respective clauses of 19. That means they have given few clauses, they can fit those restrictions under this. If they can fit the restrictions under this, then those restrictions will be considered most likely as reasonable restrictions. Sovereignty and integrity of India. For that reason, if someone is trying to impose reasonable restrictions on your freedom of speech, then they can impose. And if someone says because you are speaking, the security of the state might be in danger, then if they want to impose reasonable restrictions, then also they can impose. Then because someone is talking, or if someone is using or exercising their right of freedom of speech, India's friendly relations with some foreign state is in danger of being in despair. In such cases also they can restrict public order, maintaining public order, decency, contempt of court, defamation, incitement to an offense. In all these cases, reasonable restriction can be imposed. That means you won't get absolute freedom of speech to say whatever you want to. If whatever you want to say affects any of these, then the state has every right to impose a reasonable restriction. So again, there are so many case laws. If you wish to read about freedom of speech, especially of late, there have been many actually. And one more thing which we have already seen, reasonable restriction cannot be imposed by executive action. That means some IAS Babu or someone cannot impose reasonable restriction because they did not like what you said. It has to be through a law. Through law means what? It has to be enacted in the parliament. Unless it has been enacted, and unless there is any provision in the law which says this particular exercise of freedom of speech is against any of these which we mentioned just now, only then one can impose reasonable restrictions. Otherwise, no. Protection of life and personal liberty. Let's see what exactly we have in store here. Article 21 confers on every person the fundamental right to life and personal liberty. Okay. So the right to life includes those which make life meaningful. Okay. That is also there, apparently. The right to live in freedom from noise pollution is a fundamental right. This is very interesting. If someone is creating too much of noise, and if someone is disturbing your peace because of the noise which they are making, in that case, we can say, I have right to freedom, live in freedom from noise pollution. You can definitely complain because Article 21 gives you that right. And noise pollution beyond permissible limits is an inroad into that right. That means if there is some permissible limit, if it goes beyond that, then you can definitely complain. And the state should make sure that your right to live in freedom from noise pollution is not violated. This is a very interesting case law wherein someone was denied passport, and they approached court saying without passport there is no question of traveling abroad, but right to travel is included within the expression of personal liberty, so therefore it cannot be done. So that's a very interesting case law. Satwant Singh Sawhney versus APO. It was in 1967. Okay. Right to education is there. Right against exploitation. Article 23 of the Constitution of India. What does it say? Traffic means how can I put it? Dealing in human beings and beggar and other similar forms of forced labor are prohibited, and any contravention of Article 23 shall be an offence punishable with law. Okay. No child below age of 14 years shall be employed to work. In fact, why 14? Right against, you can even make it 18, no? Because anyway, a person won't have attained the age of majority until 18. So why make them work before that? Right to freedom of religion. This has been in news since some time in India now. So let's see what exactly we have in store here. Freedom of conscience and free profession, practice and propagation of religion. So it is up to you to decide whichever religion you want to follow or not to follow any religion. That is also fine. Freedom to manage religious affairs. Freedom as to payment of taxes for promotion of any particular religion. Okay. Freedom as to attendance at religious instruction or religious worship in certain educational institutions. To do all this, you have the freedom. Okay. Basically, it all comes under the freedom of right to freedom of religion. Then comes the right to constitutional remedies. I'll take a break of a minute and then we'll continue. Okay, welcome back. Right to constitutional remedies. Article 32 guarantees the enforcement of fundamental rights. Okay, enforcement. Article 32. Facts. Remember. So if you underline wherever you think this may come up as question, that should be more than sufficient for you to revise the same a day before the exam. Remedies for enforcement of fundamental rights. So what if your fundamental rights are not being enforced, and what can you do? It is a cardinal principle of jurisprudence that where there is a right, there is a remedy. And if the rights are given without there being a remedy for their enforcement, they are of no use. That means if you give someone a right and no remedy if that right is not implemented, then there is no point of giving any right at all. Okay. Article 32 makes it a fundamental right that a person whose fundamental right is violated has the right to move to the Supreme Court. This is very interesting. So, how can you move to the Supreme Court? Through Article 32, because it gives you the right if your fundamental right is violated. But they also say it is really a far-reaching provision in the sense that a person need not first exhaust the other remedies and then go to Supreme Court. This is very interesting. Normally, what happens? How do you reach Supreme Court as a party to the case? You first probably file a case in district court, then it may go up to high court, and then finally it may reach Supreme Court. But in this case, they say you don't have to go through that. You can directly go to the Supreme Court because Article 32 gives you that power. So he can directly raise the matter before highest court of the land, and the Supreme Court is empowered to issue directions or orders or writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of the right. So again, your right may be violated. Based on how it has been violated, the court will pass certain orders. So like this, any of these might be passed based on the circumstance, basically. The right to move to the Supreme Court is itself a guarantee right, and the significance of this has been assessed by Gajendra Gadkar. Okay, so mostly a justice. So yes, mentioned that in following words. You can read it, not very important from the point of view of exam. Now let us look at directive principles of state, the principles which have been laid down for state to follow. Okay. Hmm. Okay, these are all self-explanatory. I won't get into this. Huh. This will read important directive principles. The important directive principles are enumerated below. State to secure a social order for the promotion of welfare of the people. Whose responsibility? State to make sure there is social order for what? For the promotion of welfare of the people. The state must strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political should inform all the institution of national life. So basically, the state is being held responsible to make sure that there is social order, so that the welfare of people is taken care of. The state shall, in particular, strive to minimize the inequalities in income and endeavor to eliminate inequalities in status. Again, they have been directed to do this. How far they have achieved is a different matter altogether. So, so what they're trying to say is, when you have the responsibility of welfare of the people, you should make sure that there is no discrimination when it comes to opportunities, not only between individuals but also among groups. You cannot favor one group over another. So that is something you cannot do, and make sure that no one else also does. Okay. So that men, women, and citizens are treated equally, have the right to adequate means of livelihood. That is also important. How does one even live? So there should be some means of livelihood. So we should make sure that that is provided for. Again, there are certain things which are obvious. I won't get into that at all. Okay, these are all self-explanatory. Now let's look at fundamental duties. Just like we have rights, we will also have fundamental duties. So there cannot be any right without any responsibility. So that those responsibilities are in the form of duties. So what are those duties? On every citizen of India, they say to abide by the constitution and respect its ideals and institutions. That means make sure you respect the constitution. How do you respect? By following the constitution. If someone says I respect the constitution and goes against the constitution in their every action, then what is the point of even saying that they respect the constitution? Respect should be in deed. Okay. Then you also should respect the national flag and national anthem. Okay, but I hope that they'll stop this practice of playing national anthem in theaters. The most inappropriate place to play national anthem. Anyway, to cherish and follow the noble ideas which inspired our national struggle for freedom. Okay. To uphold and protect the sovereignty, unity, and integrity of India. All these are obvious points. I won't get into that. To defend the country and render national service when called upon to do so. If at all the government calls you to serve the country, maybe they may ask you to, what is that, join military. So maybe then you will have to. So just be aware. To value and preserve the rich heritage of our composite culture. Composite, we don't have any one culture, no? It's a combination of different cultures. So value and preserve everything, not just what you consider as your culture. To promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious. So that means religions, I guess it should be. Anyway, so sometimes what happens, people may narrowly think only from the point of view of their religion. Like, I'm only worried about people of my religion. Someone might think like that. Someone might say that brotherhood is there only amongst people of my religion, or people who speak the same language which I speak, or people who come from my state. So you can't do that. There should be harmony and common brotherhood, irrespective of their religion, language, or where they come from. To value and that is the no. To protect and improve the natural environment, including forests, lakes, rivers, wildlife, etc. Okay. To develop the scientific temper, humanism, and the spirit of inquiry. Okay. The rest are pretty obvious. Again, the same thing has been mentioned here in the form of a diagram. You can check it out. So the next major topic is that of citizenship. Let's see what exactly is mentioned. National citizenship remains an essential and enduring feature of modern life. Like, you have to be a citizen of some country, right? Articles 5 to 9 of the Constitution determines who Indian citizens at the commencement of Constitution are. That means, if you are already in India at the time of commencement of Constitution, then what will be your status? Let's see. Article 5 provides that at the commencement of Constitution, every person who has his domicile in the territory of India, that means who is living here, and who was born in the country of India, or either of whose parents were born in the territory of India, either of one of your parents, if they were born here in the territory of India, who has been ordinarily resident in the territory of India for not less than 5 years. Let's say you are some foreigner who has been residing here since last 5 years. You would also be considered as citizen. This is again when, if you were here at the time of commencement of the Constitution. Okay. Okay, then that's all they talk about. Yeah. So there is one more important thing here which is important. The Constitution under Article 11 expressly left acquisition and termination of citizenship and all other matters relating thereto to the Parliament. This is very important. Right now, who has the power? The Parliament has the power. The legislation related to this matter is coming under the Citizenship Act of 1955. Okay, that is very important to know because there have been issues of late. So you will know what I'm talking about. So that is all related to this. Next, there shall be a Parliament for the Union of States. Central government is nothing but a union of states. So for that there will be a Parliament which shall consist of President and two houses to be known respectively as the Council of States and the House of People. Okay. So this is what they say. The President shall be elected by the members of an electoral college. President election is actually due, I think, in sometime in June. So if you closely follow what exactly is happening there, you will get to know a lot of things. So who gets to elect the President? It's not just members of Parliament. So it is, of course, members of Parliament. On top of that, elected members of the legislative assemblies of the respective state. So they will also have enough number of votes. Like, it is not like ad hoc basis, like if you are an MLA, you will get 100 votes. If you are MP, you will get 1000 votes. No. It is dependent on the state as well. Which state are you representing? So based on that, certain points are added to your vote. So finally, it will be taken into consideration, and then whoever gets the highest number of points, they will be considered as the president, or they will be elected as president. So then there are powers vested with the position of the president. So which are the powers? Administrative power, military power, legislative power, and judicial power. Different types of powers, not very important. I'll just skip that part. Okay, Council of States is something which we mentioned earlier. So that is nothing but the Rajya Sabha, the upper house of the Parliament. So it consists of 12 members to be nominated with the President and not more than 238 representatives of the state and of the union territories. So 238, and how many members can be nominated by the President? 12 members to be nominated by the President. So how will they be nominated by President? Consist of persons having special knowledge or practical experience in this field of literature, science, art, and social service. If someone is from this field, then the President can actually nominate those people if he feels they may serve the nation well by being in Rajya Sabha. Lok Sabha is the house of people. Why? Because people are the ones who elect those representatives, no? Member of parliaments. So that's why it's called the house of people. And of course, it is also the lower house. So they say the maximum strength of the house envisaged by the constitution is 552, which is made up by the election of up to 530 members to the represent the state, up to 20 members to represent the union territories, and not more than 2 members of Anglo-Indian community to be nominated by the Honorable President. So Honorable President will nominate 2 Anglo-Indian community members. Then we have the Council of Ministers. Again, all this is fairly obvious, something which you would know already, so I won't get into that. For every state there shall be a legislature which shall consist of the governor and one house in the sense like Lok Sabha or Rajya Sabha. But in states of Andhra, Bihar, Madhya Pradesh, Maharashtra, Karnataka, Tamil Nadu, do they still have Tamil Nadu? I am not so sure. Telangana and Uttar Pradesh, we have 2 houses. So just like we have Lok Sabha, Rajya Sabha, here also we have 2 houses. That is in the state. So one is known as Legislative Council and the other is known as Legislative Assembly. If you are part of a Legislative Assembly, you will be known as MLA, Member of Legislative Assembly. If you are part of a Legislative Council, you will be known as MLC. So I am not so sure about Tamil Nadu. Somewhere I may have read wherein Tamil Nadu has actually removed that thing, practice. I'm not so sure. Just check it out. Again, just like the country or the union has president, states will have the governor who will act more or less like a president who acts for the country. So the governor is that person who will be taking care of the state. Again, there are certain things about governor. Please do read. Nothing much which needs explanation. Then comes the judiciary, of course, highest court, Supreme Court. So then we have the high courts and then all the district courts which can be considered as subordinate courts. Okay. Again, courts can be further subdivided into civil courts and criminal courts. That is the obvious. I'm just trying to see if there is anything important here, because these are all, there are no facts here. I'm just trying to, okay, read all these things as a story, so that you will be able to understand what exactly is mentioned here easily. Otherwise, if you are reading for the first time and if you are reading with an intention to memorize something, then it will be very difficult to do that. So never do that. First of all, whenever you are reading for the first time, you should not worry about memorizing that. You should read it just like story. So then you will not have that pressure. If you think of memorizing in the very first reading itself, then you will be subjected to mental pressure unknowingly. So your mind will consciously tell you, okay, you will have to remember this. Whereas if you read it like story, there is nothing for you to worry about it. You will think of this as some news item which you are reading, or newspaper which you are reading. So but when you do that without any pressure, so you will actually grasp whatever is there much more effectively. And when you read it for the second or third time, then it will be easy for you to remember. So you don't have to work hard to remember anything. That's my point. That's it. The moment you try to do that, then you'll end up not remembering stuff. You'll simply get confused. That's it. Earlier I mentioned all these writs, so wherein we can move to Supreme Court and they can issue all this. So now let us look at the type of writs. Habeas corpus, this is something which we have seen, you would have heard often in newspaper. Effective bulwark of personal liberty, let's see, is a remedy available to a person who is confined without legal justification. So if someone, if any state arrests you without any reason, without any legal justification, so you can opt for this habeas corpus. Habeas corpus means to have the body. When a prima facie case for the issue of writ has been made, prima facie case means if you prove sufficiently enough to Supreme Court that your client, that is the lawyer, if he proves that his client has been held without any legal justification, then Supreme Court can issue a writ of habeas corpus. This is in when a prima facie case for the issue of writ has been made, then the court issues a rule nisi upon the relevant authority to show cause why the writ should not be issued. So then they will issue a show cause notice. This is in national order to let the court know on what grounds he has been confined and to set him free if there is no justification for his detention. Many people have actually got bail based on this writ itself. This writ has to be obeyed by detaining the authority by producing the person before the court. Under Articles 32 and 226, any person can move for this writ to the Supreme Court and High Court respectively, and applicant may be the prisoner or any person acting on his behalf to safeguard his liberty. Okay. And no man can be punished or deprived of his personal liberty except for violation of law and in the ordinary legal manner. Again, as I said, it is all good and nice to read all this stuff, because when you read this you feel like, okay, you will always be protected against the misuse of rules and the misuse of powers by the state. But we see many cases where people have been confined without any legal justification, without them being charged at all for years together. So when that is the case, what's the point of even having these type of writs? Mandamus, writ of mandamus, that is the writ of command. It is a command issued to direct any person, corporation or the lower courts or government itself, requiring them or him or it to do a particular thing specified therein. You have to do something. What is that something? That is the command which is given, which pertains to his or its office and is further in the nature of a public duty. Basically, it could be to anyone to do certain things. The writ is used when the inferior tribunal has declined to exercise jurisdiction, while resort to certiorari and prohibition arises when the tribunal has wrongly exercised jurisdiction or exceeded its jurisdiction and are available only against judicial and quasi-judicial bodies. Mandamus can be issued against any public authority. Okay, what it is trying to say is, so if at all someone has passed or someone has done something to, if they have wrongly exercised their jurisdiction or if they have exceeded their jurisdiction, so then you can use this writ. It commands activity. The writ is used for securing judicial enforcement of public duties. In a fit case, the court can direct executives to carry out directive principles of the constitution through this writ. That means we know that directive principles of the state are for the state machinery to follow mostly, and if they do not follow, you have every right to approach the court with writ of mandamus, wherein the court can direct them and tell them you follow this. So that's a command which the court is giving to these state officials. The applicant must have legal right to the performance of a legal duty by the person against whom the writ is prayed for. It is not issued if the authority has a discretion. That means the person who is supposed to do has to do. It's not under their discretion. For example, let's say there is a government employee who recently retired and he's supposed to get the pension. He has to get. There is no question of him not getting. There is no question of the state having the discretionary powers whether to give or not. No. And in spite of that, if the state does not give him the pension, then the person can approach court and ask for writ of mandamus, wherein if he prays for writ of mandamus and if the court sanctions that, then the state will have to follow that particular order. So okay, then there are a couple of other writs. Let's quickly go through this. Prohibition. The writ of prohibition is issued to an inferior court, preventing the latter from usurping jurisdiction which is not legally vested in it. Okay. When a tribunal acts without or in excess of jurisdiction, that means if they go beyond their powers, then writ of prohibition comes into picture. This is very important. This is available only against judicial or quasi-judicial authorities, not against public officer. Okay. Certiorari. It is available to any person whether any wherever anybody or of any body of persons having legal authority to determine questions affecting the rights of subjects and having the duty to act judicially in excess of their legal authority. Okay, let's see what exactly this is. The writ removes the proceedings from such body to the High Court to quash a decision that goes beyond its jurisdiction. Again, similar. Under the Constitution of India, all High Courts can issue the writ to certiorari throughout their territorial jurisdiction when the subordinate judicial authority acts without or in excess of jurisdiction. That means who can issue? High Court. For instance, and why? Because if the district authority or district court or whoever is subordinate to High Court, if they do anything without or in excess of jurisdiction, when they don't have jurisdiction, they have done something, or when they have jurisdiction, they have gone beyond their jurisdiction. So then writ of certiorari can be issued. In contravention of the rules of natural justice, if someone has done something which goes against the principles of natural justice or commits an error apparent on the face of the record, so that is obvious. So in such cases, you can issue this. Okay, then they say prohibition and certiorari are more or less same, but prohibition is available quickly, whereas certiorari is available in the later stage. So if all the other authorities have been all the other powers have been exercised, and if nothing else is there, then you can issue or rather exercise that right. Quo warranto. The writ of quo warranto enables inquiry into the legality of claim which a person asserts to an office or franchise and to oust him from such position if he is an usurper. The holder of the office has to show the court under what authority holds the office. That means if someone occupies a public place or public office unconstitutionally or without having the legal right, then quo warranto can come into picture and oust them. So yeah. Major constitutional amendments since 1951 up to 2019. Okay. See, this is very important. Added 3 more grounds for restriction on freedom of speech. Until then, there were no such grounds, but now they have. Public order. This is very vague. To maintain public order, we will restrict your freedom of speech. What is public order now? Who will decide? Will you decide? Who gave you the right? This particular constitutional amendment gave them the right. So whenever the law is vague, you can easily be assured that it is left for interpretation, wide interpretation, and can be openly misused. So that is there. Again, all these are major amendments. There is nothing much to explain. You just go through these ones. If at all you feel like you need further explanation, you can drop a comment below. Maybe if I can explain through comment itself, I will try. Or what you can do is just go to our website, register for CSEET free course, and there in that free course you will get everything. For every chapter you will have detailed explanation. Here in crash course we are not looking at detailed explanation. We are mostly looking at from the angle that you have already studied this. This is more like a revision or something of that sort. So we have done Indian Constitution, Indian Contract Act is over. So law of torts is there, company law is there, and then we have company legislation, company secretaries legislation. I don't think we need more than 2 classes now. Let's see. So we'll again continue the same tomorrow as well. See you tomorrow at what time? 7:30. So once again, before we end or wind up the session, let me reiterate. Please do check out our community post put up by CS Lok. So it's a lengthy post, but it deserves that much of attention because it cannot be put aside in a couple of paragraphs. So it talks about, this community post talks about the scope of CS or any professional course in general. So don't listen to opinion of others who may or may not have knowledge about CS course. Opinions, people can give thousands of opinions, but the problem is they wouldn't be aware too much about the course at all. So without being aware of what exactly is the role of company secretary, you get to hear a lot of stuff. So you make sure that they also read these type of posts. I mean, especially this particular post. So they should know what exactly they are doing is